Committee that he chairs. Senator Ericksen claimed a daily allowance for February 7th, even though he was absent that day from meetings of his own Energy, Environment, and Telecommunications Committee and for the Transportation Committee. In addition, Senator Ericksen claimed daily allowances for February 1st when it was well established by media reports and his own acknowledgement that he was held up through the day in Washington, D.C. and arrived in Olympia only for one late night committee meeting, hardly a majority of the business day. Factual evidence supporting this claim is summarized primarily in plaintiff's exhibits 1, 3, and 4 and the accompanying source documentation with them. The evidence may actually be stronger than what we have so far, since we have not received records on payments of daily allowances made to Senator Ericksen after February 12th. The evidence on this claim for petitioners, is factually sufficient to support the claim that Senator Ericksen accepted daily allowance payments for days he was not actually engaged in legislative business for all or the major portion of those days. Senator Ericksen's acceptance of daily allowances for January 31st, February 1st, and February 7th at least violate RCW 44.04.120 because he did not qualify for those payments. Thus, this claim in our amended petition is legally sufficient as malfeasance, that is, the commission of an unlawful act, as defined under RCW 29A 56-110, subparagraph 1B. May also be, for malfeasance under 1A, it may also be misfeasance under 1B. The court, because of the factual sufficiency and the legal sufficiency of our claim on daily allowances, should therefore approve that claim for moving forward to petition gathering. Number 2, the amended petition also asserts claims justifying recall of Senator Ericksen because A, he's missed a sizable majority of legislative days due to his temporary full-time job in Washington, D.C., and furthermore because B, he has similarly failed to carry out his specific legislative responsibilities above and beyond just being present, namely his serving as chair of one committee, vice chair of another, member of at least one more committee and possibly 2, and promoting the bills he himself is supposedly sponsoring.
So, Mr. Gockley,
Yes.
Where is it laid out that the senator is required to be in certain places at certain times for certain periods of time?
Your Honor, it's not. There is no job description for a senator. There is no.
I appreciate hearing that because I looked.
Yeah, no, and you won't find a WAC, you won't find an RCW.
There's nothing in the statute or the Constitution.
No. So 29A 56 talks about standards, rules, or laws. Mm-hmm. And so I appreciate the question because it really gets to the heart of some of these other claims in the petition. There is no law, there is no rule, there is no written protocol or policy, but the word standard must mean something, and it must mean something other than those, or it would be redundant. So,
well, so that does get to the heart of the question, right? Because the question is it up to the court to set that standard, or is it up to the voting public to set the standard to say this person has fallen below that standard and therefore we elect someone else in a regular election? I'm having a real problem with the petition in terms of that issue.